In a few minutes, we're just going to let everybody log on. We have over 160 people registered as of this morning, so we'll give everyone a few minutes to get on the webinar. Okay, I see the number climbing second by second. Well, I'll go ahead and get started with the announcements. Welcome everyone to a brief overview of the intersection of landlord, tenant, and fair housing law in Florida. We're so glad so many people are excited to join us today about this topic. And we are very fortunate to have Dr. Andrea Mosley and Suzanne Garrow as our presenters. I'll give you their bios in a couple minutes. First, I just want to make a few housekeeping announcements. This is being recorded. If you have coworkers who forgot to sign up or forgot which webinar they were getting on today, it's okay. They will have a chance to watch it on demand. They can actually watch it after the webinar has concluded. There is CLE credit out there somewhere in the world. I just have not gotten the approval yet. So as soon as it comes to me, I will send it out to everyone. And once we get started, I'll put the link to the Googled shared drive in the chat box. That's where you can find the PowerPoint presentation and the CLE certificate when it arrives. And this webinar is scheduled for an hour and a half. We will have plenty of time for questions, so be sure to just type your questions in the Q&A box, and I will get to those as soon as we can, but I'll be keeping track. So don't wait until you forget what your question is. Just go ahead and type it in there as we go along. So as I said, we are very grateful to Andrea Mosley and Suzanne Garrow for agreeing to do this webinar. Obviously, there are a lot of people interested in this topic, and I just want to thank them for all the work they put into this. It takes a lot of hours of prep to get one of these going, so I really appreciate them taking time out of their busy schedules to do this for us. Dr. Andrea Mosley has been the managing attorney of the Fair Housing Programs at Community Legal Services in Mid-Florida since July 2018. She's been there longer though. That was just when her new title started. She has been litigating cases in the consumer housing and fair housing units at CLSMF for the past 6 years. Prior to her time at CLSMF, Andrea was a solo practitioner for several years and an assistant public defender for the 9th Judicial Circuit. Andrea was born and raised in Connecticut. She went to law school at Quinnipiac University. I should have asked you how to say that.
Yeah.
Thank you. In Hamden, Connecticut. Her first job directly out of law school was as an assistant public defender. The skills she learned in that position serve her to this day. She has extensive jury trial, bench trial, and administrative hearing experience. As a solo practitioner, her practice always centered around consumers and tenants. As a direct result of her childhood experiences, she has a passion for advocating on behalf of the marginalized and disenfranchised. She has too many dogs, loves to draw, swim, and ride her motorcycle. Welcome, Andrea, and thank you for being here to give us this training. Next up, we have Suzanne Garrow. Suzanne received her JD from Northeastern University School of Law, and she practiced law in Massachusetts for the bulk of her career at a private legal aid firm, which was a busy litigation practice focusing on low-income clients and exclusively representing tenants in landlord-tenant disputes and fair housing. So she has a lot of experience in this area of law. And lucky for us, after living in the Northeast all her life, Suzanne moved to Florida for a change of scenery in 2015. Upon moving to Florida, she served as a law clerk to several judges, and then joined the staff of Jacksonville Area Legal Aid and is a staff attorney in the Fair Housing Unit and the coordinator of the Eviction Defense Self-Help Project. So these two ladies are busy ladies. Thank you again for being here for us today. We're going to go ahead and get started on the presentation. And I'm Christy Baglow, the Director of Statewide Training. I forgot to say that at the beginning, but I'll be here in the background.
Okay. Good afternoon, everyone. let's get started. If you have any questions, ask them. Suzanne is super smart. I'm just crazy, so, but Suzanne will tell you this stuff. All right, you ready? And I only make people say doctor because it makes me chuckle. I'm not really that pretentious.
Do you want to get a feel for who we have on the webinar first, Andrea?
Yeah. Yeah, go ahead.
Okay, so the first poll I'm going to run is what we call the Icebreaker Poll, just to give us an overview of who's joining us, whether you're a legal aid attorney, a pro bono attorney, in management, law student. I hope I didn't leave off too many people's jobs. Tried to give a broad overview. Okay, so it looks like the majority are legal aid or legal services attorneys. And we have quite a few pro bono attorneys attending also, some paralegals. So let me show everyone the results. And while we're looking at the results, I do want to encourage anyone who's a law student or a pro bono attorney to reach out to your local legal aid if you're not already connected and ask where you can help. We are expecting a flood of new cases once the eviction moratorium ends, so they can always use your help. And we have one more poll about your level of experience with fair housing and housing law. Let me get that up. So there's two questions on this one, just to make it tricky. What's your level of experience with housing law? And what's your level of experience with fair housing? All right, it looks like the majority of people are 0 to 2 years. We have quite a few in the 3 to 5 year range too, so I'm going to show everybody the results. Well, welcome everyone. We're glad to have such a good variety of attendees today. I hope you get a lot out of this webinar. All right, take it away, Andrea.
All right. Wow, that's great to see that we have so many legal aid attorneys and pro bono attorneys and in between. I just want to let you guys know that the sky just opened up here, so hopefully I won't lose my connection. But if it does, I'll call back eventually. This is the law that is going to apply for when we discuss landlord tenant and the intersection with fair housing. So you're going to have all the federal laws. You're going to have Chapter 83, Chapter 723. All these laws are going to apply. I saw a typo, but don't look at it. It's okay. We blame the dog around here for typos. So are you ready to begin? Shall we, Suzanne?
Let's do it.
All right. Next slide, please. All right. So for residential tendencies, it's Chapter 83. So the tenant pays rent but doesn't own the property. This would also apply in the mobile home setting when they are renting the mobile home. If they own the mobile home and they are renting the lot, then which law applies? I just gave you the answer. Which one? Let me know. Anyone? Anyone? There you go. I love making people give me answers. That's how I know you're awake. All right, next slide. Christy, did we lose you? Or did I lose you?
I think Christy, there we go. Oh, we lost Christy.
Oh no. Technical difficulties. Hold on. Technical difficulties, my friends. Hold on. Let's see. It might be a storm where she is.
Hang with us. We don't have the capability to get the slides back. We will get Christy.
Okay.
Yeah, unfortunately, it sounds like it's storming around, so.
All right. No. Yes, she got disconnected due to the storm, so hopefully she can reconnect pretty quickly. We apologize, folks. Give us just a couple minutes, okay?
Now we know to make sure we have multiple capabilities to show our slides. Sorry, folks.
So funny. Hold on one sec. All right. Okay, I'm gonna see if I can share my screen. Hold on one sec. No. This is fun. Well, I think you're the host now, Suzanne, so maybe you can pull up the webinar and share your.
Okay, let me see what I can do here.
While we're waiting, we are going to discuss the moratorium and COVID in regards to landlord tenant. So think of any questions you may have in that regard. Make sure we get to those. Are you having issues with rent in the registry? Are you having issues with judges still proceeding with evictions for non-payment but not issuing the rent? What type of things are you seeing while we're trying to get the webinar back up?
How's that?
Awesome.
All right.
Hi, Sharon. I see your question. So 83 would apply if they are renting the mobile home. If they are just paying lot rent, then 723 would apply.
Okay. Are we?
I'm sorry if I'm pronouncing that wrong. I think that's the question of the day. If the client hasn't paid rent in 5 months since COVID and the moratorium ends, what now? I think that's what we're all trying to figure out. What now? I mean, it's going to be a horrible mess, is I think what's now. But I think it's important for us to, if we can, as much as possible, proceed in a consistent form And then someone may have to go to court, to appeal some of these judges' decisions, because depending on where you are, the judges kind of do whatever they want. And then there are other judges who won't do anything in regards to evictions. And then there are other judges that will do everything.
Yeah, yeah. That brings up a very good point. Is if you think there are going to be issues, then you need to have a court reporter with you so you can make those appeals. So
exactly, you have to talk to your employers about budgeting for court reporters, because you're going to need a lot of them. Especially when you're making arguments, and we'll get to this in regards to written to the registry for non-payment on an eviction that's filed during the moratorium. For non-payment, you definitely need a court reporter, because you're going to be fighting. If you fought with your judge before, it's just going to be like 10, 20 times worse.
And for CARES Act protection as well, and we'll talk more about that. Those are all going to be affirmative defenses or other types of arguments that you're going to want to make and preserve. So we'll get more into that at the time, because I think it's going to be, as Andrea said, it appears to be wide open already what's happening in the courts. And once evictions are filed again, then there's going to be even a greater variety of how judges are treating these cases and the requirements.
Okay, so we'll get back to the presentation. Let me answer this one last question. When can a landlord send a notice? What do you mean? In regards to non-payment? I don't think anything prevents the notice. And when will the court most likely issue writs? I would say that the writs are going to be issued as soon as the moratorium is lifted. So I think it's going to be en masse, really. I think you're just going to see a whole bunch of them at once.
And again, it does vary not only by county, but by judge, what's happening with these cases. There are also some jurisdictions and sheriffs that are allowing writs to issue. And so I don't think the moratorium applies for a variety of reasons. So it's really, again, all over the board, but while you're in court, you're going to want your court reporter.
Yeah, if your judge followed the law before, they'll probably do everything they can to err on the side of not doing anything. If your judge did whatever they wanted to before, it'll just be more of the same. Is the best I can gauge for you. And I think that really depends on whether you're in the city or whether in your more rural areas. At least that's where it is in Osceola County. The more rural you get, and you're not going to have a lot of landlords who have federally backed mortgages and those type of things. So you'll see a lot more prohibited practices and things like that. Here in Central Florida, we have a lot of prohibited practices, a lot. So if you haven't seen that yet, the wave will be coming, because it's already here in Central Florida. You're welcome. All right, so let's get to the slides, and then we'll answer some more questions. You have two types usually of rental agreements, and that is an oral agreement and a written agreement. And so the oral agreement, you want to talk about that, Suzanne, the oral agreement?
Well, oral agreements are just that, non-written rental agreements. There's obviously problems because there could be misunderstandings and issues of proving what the terms of the agreement are. I say there's a benefit in that there's some flexibility, and the reason why I say that is because of what we are seeing in terms of the prohibited practices and other, or I will say discrimination and bad acts. It allows, if you have a month-to-month oral agreement, if the tenant pays on a monthly basis, they can get out of that agreement and and get away from those bad acts. And typically we think Florida law is contract driven and a lease is desirable, but as things ramp up here and potential for bad actors are out there, the flexibility may be an okay thing. And I'll just let everybody know I can't see the questions, so I'm going to rely on Andrea to read them as she's been doing, because while I'm sharing my screen, for some reason I can't see them. So
yeah, that's okay. Don't worry. I will do so. In regards to written agreements, they have the benefits of giving you a contract that can be enforced and should not be violated. And any changes to that contract need to be in writing, signed by both parties. The downfall of that is you have to be released from the lease. And typically in the lease agreement, there are penalties for being released from the lease agreement. And also, depending on why you're released from the lease, sometimes they will also require a waiver of any kind of claims you may have against them now and in the future. So just be aware of that. Ready for the next slide?
I'm trying.
Fun. I see more questions. Hold on, give me 1 second. So a written lease agreement tells you the term of the tenancy, the names of all the tenants, the limitations on occupancy, the rental amount, the terms, the security deposit, the terms of the security deposit, the landlord's responsibilities in addition to what is required by law, restrictions, access to the property, disclosures. It needs to be signed by the landlord and the tenant. And then there are certain fair housing considerations.
So when you review a lease for a client, or when a client comes to you with their lease, there can be illegal lease clauses in that lease. And putting aside the consumer protection related clauses, there can be a no animals restriction across the board. There can be no kids. There can be requirements for pet deposits for animals that may be assistance animals, whether service animals or emotional support animals. So it's important when reviewing a lease to be mindful of the potential fair housing considerations and violations that might be contained in that lease, or rights that otherwise tenant might be entitled to but are not enjoyed through this lease.
All right. Let me answer a couple of questions before we get too far ahead. Can you provide typical examples of prohibited practices? If rent includes lights, disconnecting the power, putting someone's possessions out on the street, or changing the locks because they haven't paid rent.
Taking off the door.
Hmm?
Taking off the door.
Oh, taking off the door. My goodness. I haven't heard of that since I was a teenager. I won't tell you why. But yeah, those are types of prohibited practices. Self-help evictions like that are strictly prohibited by Florida law. Any kind of disconnecting the access card to get into the complex, all of those things are prohibited practices because they haven't paid rent. So bear that in mind. Is there recourse, Suzanne, is there recourse for students who signed a lease, but due to COVID, classes will be online and they will not be in person at the college, and they want to break the lease due to COVID? Ooh, that is an excellent question.
It's an excellent question. And back to law school, it depends. I think is the answer. So COVID in itself is may or may not be a qualifying disability. But if somebody has a disability that could be exacerbated by COVID, I think there is a request for an accommodation that could be made in those circumstances. But I think alone, if it's because the school has been closed and you have this lease, I don't think that, short of having something that would otherwise qualify as a need for reasonable accommodation, I'm not aware of any other way out of that lease, at least at this particular time.
I would say if it's student housing, probably. You could probably get out of it, but otherwise, no, it's a contract. But what do you think are the kind of damages someone could face, Suzanne? Considering in this environment, the landlord may not be able to mitigate their damages.
I think the term of the lease is a potential. I think that always is there potentially.
Mm-hmm. Do you think maybe they could argue something like act of God?
They could argue. I think they could try.
Their defense?
They can try, but I think ultimately,
I just made
there's a contract. It's unknown. It's all unknown territory. I think it's a good point here.
Yeah. So I would say if your lease has a clause for, I think those are always better. If there's a clause in there that says if you terminate the lease early, this is what you'll pay. I think that's always better. So that way you're not going to be on the hook for the entire term of the tenancy. But I would try my best to argue, it's a disaster. Because of a disaster, I can't, move in because school is online, and I'm sure the state is going to shut back down. So try everything, but there's no definite answer at all. And Suzanne, I have a little box that's showing up and it's blocking some of the words. Are you seeing the box?
Yes, but I don't know how to get rid of that box. Let's see.
There
we go.
Okay. From Dawn, I do bankruptcy and private practice. Options for tenants at end of the moratorium is to file Chapter 13, so long as it is filed before the writ of possession, and stop the eviction, but must file back rent and schedule and make payments on back rent and keep up on future rent in Chapter 13, says Dawn. So for the tenant, I practiced bankruptcy for several years too. So for the tenant who wants to remain in possession and can't pay back rent, but can pay rent going forward, but can't pay the back rent all at once, Chapter 13 is an option. The problem, though, is I don't know how many people are going to be able to pay ongoing rent. So if they can't pay ongoing rent, they certainly are not going to be able to pay, make payments in a Chapter 13, which also includes a trustee fee and et cetera. So it really depends on the person's ability going forward. Can they pay the rent? Otherwise, the 13 is just going to be a waste of time and money for them. Hey, Christy's back. How are you, Christy?
Hi, good. Sorry about that. The computer just lost all internet. I guess Andrea's storm decided to show up on my computer. So thank you, ladies, for taking it away so smoothly. If you have time, we do have 2 questions in the Q&A box, or I can save those for your next break.
No, go ahead.
It's a little confusing because there's a Q&A box and a chat box.
Yeah, I was wondering.
So I wasn't sure if you guys could see that, but we have a question. Does a tenant have the right to cancel a lease to avoid an eviction lawsuit due to COVID?
Yeah, that's what we had discussed previously.
Okay, good. And second question, what about arguing equity at this time to judges?
Equity. Mm-hmm.
You can argue it. You can always argue it.
Has ever worked before, then it will work now. If it has never worked in the past, then.
Right. I think Andrea's point is very good. You know your judges in your local areas. And so I think those who are more open to arguments like equity and, you know, other arguments that may be more expansive of tenant rights will remain that way. And those who aren't will likely remain not disposed to those arguments.
Yeah, and I when I was doing landlord tenant strictly, we always had a clause for equity of forced forfeiture, but you know, it really depends on the judge, right? But always throw it in. I think what you're gonna have to do is throw in the kitchen sink and see what sticks. Throw it all against the wall, see what sticks. Because that's and the time I think to test that would be now. Because when you get overwhelmed, you know, it's going to be a whole different thing. So if you have the opportunity to test it now, I would try and test it now to see what's working and what's not going to work. And if you know your judge goes against you on a regular basis, have your court reporter come up with any kind of case law that would remotely relate to it. You're not going to find COVID case law, but anything that would remotely relate to what you're arguing to kind of give them something to put their teeth in. And make a good record, because it might end up being appellate practice that saves the day. All right, let's go through some more slides and then we'll answer some more questions, okay? The mobile home park leases. The slide reads, no rental agreement shall be offered by a park owner for a term of less than 1 year. So for mobile home park leases, you don't get 6 months and 30 days and 3 months. Sometimes I see 3 month leases in the 83. You have to have a rental agreement for 1 year. And if there is no written rental agreement, no rental term shall be less than 1 year from the date of the initial occupancy. However, the initial term may be less than 1 year in order to permit the park owner to have all rental agreements within the park commence at the same time. Thereafter, all terms shall be for a minimum of 1 year. If a notice of increase in lot rent amount is given within 90 days before the renewal date of the rental agreement, the rental agreement must remain under the same terms until a 90-day notice of increase in the rent is given. The notice may provide for rental terms shorter than a year in order to maintain the same renewal date. A mobile home lot rental agreement may provide a specific duration with regard to the amount of rental payments and other conditions of the tenancy, but the rental agreement shall neither provide for nor be construed to provide for the termination of any tenancy, except as provided in those statutes. So the mobile home statute gives you specific reasons that you could terminate a lease. That's why you will see what I like to call perpetual tenancies. You'll see someone move in and they only have a lease from 10 years ago. I'm like, wait, I used to find that so confusing, Suzanne. It's like, how long you been there? And they only have that one lease and it was from years ago. I'm like, I don't understand what's happening here. But that's why, in case you ever wondered. And any provision of the rental agreement is void and unenforceable to the extent that it attempts to waive or preclude the rights, remedies, and requirements set forth in this chapter. So in a lot of ways, I think mobile homes have a little more protection, but you know, it's a mobile home, so when the hurricanes come, not so good. But there is, you know, it's good stuff. All right. What's the next lease?
I'm going the wrong direction here. So let's see. Okay. So this is just something to think about at the time that a tenant is signing a lease. and requesting reasonable accommodations at that particular time. It's a good juncture to do so. So for instance, if the lease says there's a no pet policy and your client has an assistance animal, has an ESA, it's important at that particular time that it be understood, it be written into the lease. Obviously, a no pet policy doesn't apply, but it's just a very good time to raise those issues if the ESA will give your client full use and enjoyment of the home. Similarly, if there's no assigned parking spaces in a residence that your client is moving into, and your client has mobility issues, needs an assigned parking spot, disabled parking, then again, at the time of signing the lease is a good time to raise those issues, request the reasonable accommodation, make sure that your client can have full use and enjoyment of their home.
Okay. We have a couple of questions in the Q&A that I did not read. If it is their own mobile home and rent space, oh, okay, I went through that one. I have received phone calls where landlords are threatening evictions during COVID, even though executive order holding evictions. So maybe the question is that a prohibited practice, Suzanne?
Yeah, I don't think that's, I mean, I think it's, I mean, what the governor's moratorium says, if people are not paying their rent due to COVID, they cannot be evicted for non-payment of rent. Similarly, it's, I think, a little more broad in the CARES Act in terms of the nexus to COVID. So if somebody is threatening eviction due to COVID, I think it's not only, I think it's just a straight violation of the current moratorium if it's a non-payment case. I'm not sure that it's a prohibited practice necessarily, but it's not something that's contemplated in the statute, but it's certainly something that sounds illegal under those circumstances.
So if it's not a prohibited practice, is there anything you can do about the threat in and of itself? Or is that just something you add on to an eviction answer?
You know, I guess you could. I think the bar is pretty high to get an injunction for a prohibited practice and for harassment, general harassment. So I think you could try, but I don't know how successful you would be.
Mm-hmm. Or you can send the landlord a letter and say, my client has informed me that you said ABCD. As you know, pursuant to the moratorium, you cannot do this. And I think what you're doing, and please refrain from doing so again in the future or something like that. So what you're doing is you're giving them a warning, and B, that's something that you can submit later in court.
Right, Exhibit 1, so.
Yeah.
Mm-hmm.
So I would do that in that case. And so maybe the landlord will back off and think twice. And then also if the eviction is filed, now you've got something that happened before the eviction was filed where you warned them about doing something illegal. Okay.
Yeah, I mean, I don't think it's a defense necessarily to the eviction. I think, but it depends on what it is. And obviously, if they proceed in violation of some of these moratoriums, it's a defense. I think it may be a counterclaim in this particular
counterclaim.
This case.
Yeah. Are there any requirements for the 30-day notices pursuant to the CARES Act, like there is a statutory requirement for a 3-day notice?
If you're asking if it's supposed to say something in particular, I think it just needs to comply with, I'm not sure what the exact statutory requirements are other than being a 30-day notice. I don't know, would you know that, anything more about that, Andrea?
No, I
Just
haven't.
to clarify, they specified in the next question, if the 3-day notice is missing certain information, it can be deemed defective. Is that also the case with a 30-day notice under CARES?
Yeah, I mean, I would think so. I mean, I have to say, I haven't yet seen one to line it up with the statute, but I would think so.
Mhm. Okay. I would think it would at least have to conform with what it says in the act, right?
Absolutely.
If it says something different than the act, then it would be a defective notice.
It's a brave new world. You all are going to be making new case law.
If it says something different than the act, then it would be a defective notice. And so that, I think that's something you can address, but I don't recall that now I could be wrong. I don't recall that the CARES Act says that it has to be specific language like you would find in the Florida statute where certain notices have to have specific language. I don't recall that. So you have to have a look, but if there is no requirement for certain language, I would assume it needs to say this notice is being sent pursuant to the CARES Act, and then it can't misstate the act or state something that's different from the act.
And sorry.
Go ahead.
I suspect that a lot of landlords are going to are going to violate the 30-day notice requirement. So we want to make sure that it's a true 30-day notice. You know, there's likely going to be a requirement of a full rental period notice. And so just read them carefully. And we're all going to be looking at these together as they evolve and are served.
Ooh, we just got a interesting message. At this very moment, one of our landlords is removing belongings in the tenant's apartment. She is there. I told client to call the police and our attorney to email and call landlord. Anything else right now you can suggest?
Definitely call the police. That's,
Yeah.
JSO has been.
Why are the belongings being removed? I think if they're just removing the belongings without a proper eviction proceedings, then that's illegal.
Yes.
And the police officer should know that. So kind of, if there's some confusion about that, I've been on the phone with police officers. It just depends on how friendly the officer is. But usually the officers check to see what's going on first. So
We also tell our clients to provide, if they have in their possession a lease, a bill, something, if there's any question at all.
Yeah. And if possible, turn on your cell phone, start recording. I'm assuming this is an illegal eviction, so start recording. Get the landlord moving your things out. You know what I mean? There's no more proof than that. There's no better proof than that, you know? And I hope it turns out okay. Let us know. All right, so reasonable accommodations and landlord tenant. So there are situations where the reasonable accommodations can be used, fair housing reasonable accommodations can be used in response to landlord tenant issues. For instance, noise complaints. You get those a lot with children. You get those a lot, so that's familial status. You get those a lot with people with disabilities, mental health issues, autism, PTSD. Perhaps the client themselves are triggered by lots of noise and need to be in a quieter area, or not have too much noise at night. So there are options in that regard. Unauthorized occupants. So this is not going to help when somebody moves in children that they never disclosed, or, the friend stays past the time that you can have a visitor. But if you have that unauthorized occupant because you are recently disabled, or because you're in the middle of a medical issue and that person is caring for them, then mental health, live-in aid, that's a reasonable accommodation request. Violation of the no pet policy. that would be a request for an emotional support animal, if it is indeed an emotional support animal. Multiple visits by the police, right? So sometimes that's VAWA, depending on the type of housing. If the person has a mental health issue, autism, PTSD, failure to maintain the property. Ooh, my favorites, hoarders, and dirty houses, parking space issues, smoking violations, and medical marijuana. Did you want to add anything here, Suzanne?
Just that a lot of the notices that we see, notices either to cure or notices to terminate without a right to cure, they often, or on many occasions, tend to be bogus and are things that could be related to various issues. So you need to probe, that could be a disability issue. You need to probe with your clients. You need to find out what, get to the bottom of it, find out what's really going on, and find out if there is a need for a reasonable accommodation. And then, as I'll say a number of times throughout this presentation, you can ask for them at any time. We've already talked about at the beginning of the lease, then when complaints happen, like in this situation, or trying to live amongst other people, just remember that a reasonable accommodation may be the answer to the problem.
Yes, and that's the most important thing to remember. Even if you don't practice fair housing on a regular basis, just kind of remember this slide if you don't remember anything else, because a lot of times the clients will have they'll send a notice to cure, and then they'll send another one right away because they're trying to get the two within 12 months. And sometimes they'll send two notices that aren't even for the same thing, or they'll make it non-curable when it should be curable. At any point, even if it's a non-curable notice, you can ask for a reasonable accommodation request. What I will say though is if the issue is the client's mental health or some kind of exacerbation of the condition or a new condition, what will help most is that you can say that the client is now addressing the issue. Okay, that's going to give you the most traction. And most of the time, these issues happen when the clients are off their medications, and no one's been checking up on them. You know what I mean? They're not, the downside of the medication is it makes you think you're okay. And so they stop taking the medications and they're fine until they're not, right? And so you need to make sure that there's some kind of plan in place. They're on their medications now. They may even need a power of attorney or a guardian. You're gonna have to kind of take those steps to ensure that this just doesn't turn around and happen right away. And I don't know if this is coming up later, I forget, but always keep in mind, there is no accommodation for dangerous behavior, right? They don't have to give you an accommodation for something that's dangerous. So if your dog has bit someone, even if it's your emotional support animal or your service animal, if your client's off their meds and they stab somebody, right? So always bear that in mind. But otherwise, you can always do an accommodation request.
And part of the accommodation request should be to, if it was first notice or at any point, is to remove these from the file, because ideally, you don't want these hanging out there to be something that can then be acted on. This is a request, as Andrea says, my client is being compliant with their medication. They've removed whatever the problem is. Please remove this from the file so it can be a do-over, essentially, and that the slate is clear.
Excellent point, Suzanne. Yes, absolutely. You always want to ask to have the notice withdrawn or whatever the case may be, now that they're back into compliance as part of the accommodation request. or have fees removed, because sometimes they're being fined for various things daily, or there's a fine in the lease. You need to ask to have that removed, because they're either not going to accept the rent, or the rent is going to be they're always going to be behind, and the rent is always going to go to the back amount and they'll never be current. So you have to ask to have the fines removed too, in association with the violation. Any questions about that before we move on? Because I think that's kind of an important one. Let me take a look. I'm going to go to both boxes. Is there any obligation for a landlord to investigate a potential environmental issue that might be exacerbating a health condition, such as mold, for example? Ooh, mold is a problem.
Yeah, I will say though, mold is not contained in the local ordinances as something that's a violation in the state statutes, but I've had success with reasonable accommodations in mold remediation by the landlord if it's exacerbating a qualified disability. So that tends to be the one best way that you can deal with the mold issue, is through a reasonable accommodation that I've seen.
Okay. And also I would say it's good to be able to establish that there was mold. So if the client can afford it, or if you have it in your budget, test for mold before the landlord comes and displays breach on it, because then it won't show up as much mold as there actually is. So we're gonna have to speed up a little bit. And then, but let me see if there are any questions. Okay, I already. What if the dog is an aggressive breed but has not shown any aggressive signs of behavior? There's no such thing as an aggressive breed. Under the federal regs and the HUD guidance, they can't keep out a dog because of the breed. It has to be specific to that animal, specific actions by that animal. It can't be mere speculation based on breed. So they can't say, we don't want pit bulls here. They can't say, we don't want Dobermans here, whatever the case may be. Or we have a dog policy of only dogs weighing 25 pounds or less. They can't do it. So breed and size restrictions do not apply to emotional support animals ever at all. They can't do it. They want to, but they can't. Even if they say the insurance won't cover it. So let's speed up just a little bit, Suzanne, and then we'll do some more questions.
Okay, here's emotional support animals.
So emotional support animals are just that. They're not trained. So what you will see is there are emotional support animals and there are service animals, and people will confuse them. And people think that any kind of service animal has to be trained or registered or any of those things. None of those things are true. So emotional support animal is just that it provides comfort and alleviates one or more identified effects of a person's disability. The housing provider can ask for documentation of the disability-related need for the ESA. And the animal, it must be animals commonly kept in households. I hope you enjoyed that little cartoon. I thought that was cute. And Suzanne can testify to the fact that at this point, and I'm probably not alone, I have several emotional support animals in my house.
They're wonderful, just wonderful animals. They're adorable. So just a couple things about this. On January 28th of this year, HUD issued a guidance about ESAs, and advocates were very concerned about what would come of that in this regime. But basically what it did was just very quickly, three things. The first is it clarified in some ways the process for requesting an assistance animal or emotional support animal. And if there is a visible, a detectable disability that the housing provider knows or should know about, then there is no requirement to provide medical documentation. So that has been codified or at least contained in the guidance. In addition, letters from healthcare providers must be based on personal knowledge of the requester's disability, and we'll talk a minute about that. And also, animals commonly kept in the household, the point that Andrea rose, that has been set forth in the guidance as typical ESA and has provided for stricter scrutiny of animals that wouldn't commonly be kept in households, like barnyard animals, exotic animals, animals of that nature. So your gerbils, your dogs, your cats are recognized as ESAs, and you're going to have to provide, or your client's going to have to provide specific medical need to have a different type of animal not commonly kept in the household. July 1st, 2020, not to be outdone, Senate Bill 1084 incorporated these things here in Florida, but added to it the personal knowledge requirement. So meaning that, I mean, you could still talk to a telehealth somebody, you can talk to, you know, a healthcare provider, but that healthcare provider who is providing medical documentation, as well as the person who is providing their personal medical need for an ESA, the medical provider has to have personal knowledge. The person has to be truthful. This can't be somebody that has just signed up for a certification over the internet. And as I said, Florida, not to be outdone, has criminalized any attempts to provide documentation not based on personal knowledge or things that are questionable as truthful. So go Florida. Here we are. Senate Bill 1084, very recently enacted, obviously, signed by the governor.
Long story short, a mess, but just take it one issue at a time. There are some issues in regards to whether this could be an online thing, whether, you know, that type of thing, whether the online doctor can write the letter, and that bill clears up that. Yes, it can. And, you know, just be mindful that there are rules now in regards to the animal, because previously I used to say I could have my emotional support gator, and now I have to have a letter which says I specifically need a gator for my disability, which means no more gator, because nobody worth their soul is going to say I specifically need a gator. But you might, for a child with autism, get a letter that they specifically need this chicken as part of their therapeutic issues, and that is possible. So always try and keep an open mind on that. I see Christy's back.
I am back. We've got a poll coming up on the next slide. Just keep everyone thinking and on your toes this afternoon. All right, so this one is a segue into our next section. It's about air conditioning, critical right now. Does the landlord have a duty to provide working air conditioning? And your choices are yes, this is required under Florida law, no, this is not a landlord duty under Florida law, or this is only required during summer months. So I am going to launch this poll.
August is just around the corner.
Okay, we've got quite a few experts in here, I see. Got about half of the results in, and 80% chose no, this is not a landlord duty under Florida law. Is that possible, ladies?
That's possible.
Not only is it possible, it is true.
But if they do provide it and it's part of the package of things that they provide, then they have to make sure it keeps working.
Yeah, they have to maintain it. So if they give it to you when you move in, they have to maintain it. Now, they may give the tenant some responsibilities like changing filters and things like that. But ultimately, if they provide it, they need to maintain it. And I've never come across a judge, especially in the hotter months, who wouldn't support some type of rent withhold in the middle of the summer, because they're hot. Everybody's hot. Everybody feels the heat. So, especially in the middle of the summer, I haven't seen one judge go against it. All right, landlord duties. And for all tenancies, that's on the left, right? And it's basic, what's required by code, right? And inclusive in there is quiet use and enjoyment, don't forget that, and non-discrimination, all right? And then for apartment complexes, because there's different duties if it's a single family home, but for apartment complexes, extermination, lock keys, clean, safe condition of common areas, garbage disposal, and running water, hot water, and heat during the winter in Florida. You gotta wonder who wrote those laws. Mobile homes. So the park owner's obligations are to comply with the requirements of the same thing, building code requirements, maintain the common areas and access the common areas, maintain utility connections, and additionally, they have to comply with the park rules. So whenever you have a mobile home case, you should always get a copy of the park rules, and most people have never seen the park rules. And conversely, the mobile home owner has to comply with the park rules that they usually never look at. And keep it clean and neat, and also comply with any health or building codes. So if you own the mobile home, you're required to maintain your own mobile home, and that becomes important, especially when you have a disaster like a hurricane or whatever, that type of thing. If something happens to your own mobile home, it's your home. You got to fix that. Anything you want to add to that, Suzanne?
No, I think that's good.
How about septic systems and mobile homes?
Septic systems and mobile homes. For in what context?
I'm assuming they're talking about maintenance. Who's required to maintain it?
I would say if it comes with the mobile home, then the mobile home owner would be the one to maintain it. If it comes with the park, that would be something that the park would maintain, I think.
I'm gonna say that I'm kind of the opinion that it's gonna be the park, because if we're talking about something in the ground, that's always gonna be from the park.
Right, I guess that's a fixture of,
yeah. So if it's in the ground, then the mobile home park owners would be responsible for that. If it's something that you brought with you, then you would be responsible for that.
I will defer to Andrea on that.
I would always make that argument, because if it's in the ground, how can you be responsible for maintaining it? You're renting the ground, basically. So that would be my argument. Want to take a couple questions?
Okay.
Then you can talk about Bostock.
Sounds good.
Is there a statute based on the ESA bill or not yet? I haven't seen a statute, and these are pretty recent developments. So I'm pretty confident in saying no. You just have the bill.
Right. I think it's going to be codified at 760.27, but I don't think it has been yet. So it's the bill and Chapter 2020-76, and I think that'll be the next phase, is codifying it.
Okay. All right. So you want to talk about Bostock?
Sure. So Andrea just mentioned that non-discrimination is a duty of the landlord if covered by the Fair Housing Act, and there are exclusions and exemptions to covered dwellings. But assuming a landlord is covered by the Fair Housing Act, they have to comply with the law. And so there are a number of different protected classes, among them religion, race, national origin, familial status, and now perhaps sexual orientation and gender identity, maybe. And that's because of Bostock versus Clayton County, which was decided on June 15th, 2020, another very current matter here. Bostock was a set of 3 consolidated cases. Bostock was a highly regarded child services advocate in Georgia and was fired for conduct unbecoming a county employee. He was basically doing nothing. People in the community made disparaging remarks about him, about his homosexuality, his being gay. And the district court dismissed the case, and the 11th Circuit affirmed the dismissal, and that was the key case. There were 2 others. I won't get deeply into them, but the third of which was a case about gender identity against a funeral home. And in that case, Amy Stevens was assigned a male gender at birth, but she told her employer she intended to work and live as a woman. Within 2 weeks, she was fired. So these 3 cases, that and the Zarda case, all went up to the Supreme Court. And on June 15th, 2020, in a 6-3 decision, Justice Gorsuch wrote the opinion of the court that posed a simple hypothetical. 2 employees are virtually identical, except that one is a man and one is a woman. Both employees are attracted to men. When the male employee is fired for being attracted to men, but the female employee is not, the male employee has been discriminated against on the basis of sex. He posed a similar hypothetical relating to transgender employees who identify as female but were assigned a male gender at birth, and the employer intentionally penalizes a person identified as a male at birth for traits or actions that it tolerates in an employee identified as female at birth. The majority held that the discrimination based on homosexuality or transgender status necessarily entails discrimination based on sex. This was a Title VII case. As you may or may not know, Title VII often informs in the courts how Title VIII, the Fair Housing Act, is interpreted. So start thinking about those cases and start thinking about how we can push the next envelope here, because the door is now open to potential gender identity and sexual orientation discrimination as a protected class, I think, under the Fair Housing Act.
Yep, and this may be, what do you think, Suzanne? Is this something that you would have to argue in federal court, or do you think you can argue it with HUD too?
You know, I think it maybe after January in HUD, but I would probably bring the case in federal court now if I were going to bring it. But I think it's also, there are lots of people who are working on it, so you should definitely, I think it's going to be a concerted effort, just like marriage equality was, just like this this change to the law was. So, but look for these cases and look for good facts, because people are interested in pushing the envelope.
Yep, and you can always ask for a co-counsel or more experienced person for advice. There's the housing umbrella listserv, there's the fair housing listserv. So join those if you haven't, because those will be really good resources. Okay, you want to go to the next slide? Ooh, fancy. Tenants' duties. Comply with the obligations imposed by building and housing and health codes. Keep premises clean and sanitary, remove garbage, keep plumbing fixtures clean and sanitary, use and operate in a reasonable manner, electricity, plumbing, sanitation, ventilation, air conditioning, other facilities. Don't destroy the face damage, conduct yourself, and require other persons in the premises with your consent to conduct themselves in a manner that does not unreasonably disturb tenants or neighbors. There's going to be issues regarding hoarding and quiet use and enjoyment. So as I went through that list, in the back of my mind, I'm thinking, yep, reasonable accommodation, because it could amputate a disability.
Exactly. And there's just always a tension between those issues and those potential disabilities and the use and enjoyment by other tenants. And so you have to be creative sometimes with your clients. There is a key case in Massachusetts, where I'm from, where somebody who had mental health issues was banging the walls nightly and disturbing their tenants. And in that case, it wasn't even necessarily accommodation other than to allow them to stay because they were disturbing their neighbors, but they got him a Nerf bat. So, I mean, it really is only limited by your creativity and the need of your clients. So all trying to live and get along with their neighbors.
Yeah, and sometimes you'll have it with familial status. Sometimes you'll have it where the kids are making noise and people are complaining, especially if they're not on the first floor. Sometimes when you have someone with autism who's acting out, someone who's bipolar and having an issue and running up the middle of the street naked. These things are all things that happen. Hoarding is a disability in and of itself. So you get a pretty regular amount of hoarding cases. So be aware that that is a disability. And you may need to kind of get pictures if you get a case where they're saying if there's a violation based on cleanliness or that type of thing, or housekeeping is usually what they say. When someone gets the issue of housekeeping, I always say, send me pictures. Because they may not be in a position where they admit to being a hoarder, and nobody may say hoarder. But if you look at the pictures, usually that'll give you a good idea, especially if they only want to take a picture of this one corner. Christy's back.
Oh, we can skip the poll. You already answered the question. Since we're running behind, we'll go right on past that.
Okay.
My bad. I'm sorry, guys. You missed the opportunity to answer the poll. All right. Landlord access to the premises in case of an emergency pursuant to a court order with consent of the tenant to show the property to a purchaser or new tenant. When the tenant unreasonably withhold consent, if the tenant is absent from the premises for a period of time equal to 1/2 the time for periodic rental payments, if the rent is current and the tenant notifies the landlord of the intended absence, then the landlord may enter only with the consent of the tenant, or for protection and preservation of the premises. Absent an emergency, the landlord may enter the rental unit on reasonable notice at a reasonable time to make repairs to the premises. And reasonable notice is defined as 12 hours prior to entry. And reasonable time is defined as between 7:30 and 8 p.m. There are additional issues now in regards to COVID and the landlord entry. Mental health disabilities may need to be reasonably accommodated, and the right of entry should not be abused or used to harass.
I have many people calling me now asking if the landlord can come in to their property. And it's, if somebody has a disability that can be exacerbated by COVID, there are some limits to the entry, some parameters I think a tenant can place on the entry. I don't think it can be fully prohibited. There are people who have disabilities who may have xenophobia or may not want people in their home. And again, that could lead to a need for a reasonable accommodation. But I don't think in the end, access can be completely prohibited. It needs to be some sort of interactive process to allow reasonable entry if needed.
Yeah, it's always going to be. And I've had several of these lately, considering the fact that most people can't leave their home or don't leave now, and the landlords want to get in. If someone is dealing with a mental health issue, it's probably already exacerbated by the lockdown and the increase in cases. So if they have a medical condition that might make them more susceptible, you can always request that anyone who comes in, they limit the number of people to absolutely necessary. Because sometimes it's the maintenance man and maintenance man's buddy, or the maintenance man's assistant and all this kind of stuff, and the landlord and this. So you could say limit to the person who's making the repair, and that you wear PPE because, I have a condition that makes me, susceptible to COVID, that type of thing, or to a severe reaction to COVID. So you'll get those if you have it, because I've had a super recently, at least 3. So always keep that in mind. And if you have a case where there's excessive entry into the premises, then you need to consider the issue of harassment and sexual harassment. Some of these things are signals, so you need to always have that in the back of your mind. There really is no reason for a landlord to, or maintenance or anyone else, to excessively enter the property. Okay, so we are now withholding rent. Okay, before withholding rent, the repair must be something that the landlord is obligated to take care of, right? So that's important. If it is the tenant's duty, the tenant can't withhold rent for it. And I chuckle because sometimes people very rarely read the documents they sign. So always have a look-see at the lease. You can compare it with the Florida statutes, but always look at the lease. What does the lease say? And if the lease requires the tenant to keep this in working condition, then the tenant cannot withhold rent for it. And the tenant must provide landlord with a written notice with the opportunity to fix the problem. And the tenant must hold the rent in a safe place. After repairs, the rent is still due. Anything you want to add in here?
Just a couple points on this. The written notice is very specific. It has statutory requirements. I run a clinic at Jacksonville Area Legal Aid where we assist tenants in drafting these withholding notices. They have to list the specific conditions that are material conditions that need to be fixed. They have to state their intention to withhold rent. If it's not fixed within 7 days, the 7-day notice has to be set forth. The other thing too is that we typically assist people with notices that say both withhold rent or terminate tenancy, if not fixed in 7 days, giving people that option as well. Those are just a few other additional points on these withholding notice. But when somebody asked before about notices being sort of a statutorily driven, this one is a big one. So 8356 will drive these notices.
Yes, and that is exactly what's in the next slide. Everything that Suzanne said. Also, a big thing I like to talk to my clients about is this is not an indefinite thing, right? So a lot of times clients will do the withhold of rent notice and then just want to sit there for months and months and months. And usually that does not fly in my area. They don't want to pay any kind of rent, and they've been sitting there for months and months and months. Our court says, you know, if you're there, then there's a value to it, and you can't just pay zero, and it's not indefinite.
Well, and plus, a landlord could also illegally file an eviction for non-payment of rent, so they better have their money so they can post to the registry
Right.
when they want to assert the complete defense, which is that I was withholding due to a lawful notice to do so.
So you either save your rent or you fix it and keep your receipt, and your notice should say that. So I'm always of the belief that if you're going to withhold rent because this is something that you need and you've been doing it for a while, then you should have enough to fix the issue and provide a receipt to the landlord that it was fixed and move on. A lot of times, this is the only place that the person can't afford, and they're just withholding rent and they're just sitting there. They almost never save the rent.
So one thing, I'm sorry, one thing I'll add to that is that if you're going to make repairs, you need to get an agreement of your landlord to do that to be able to deduct. So that's what I typically will advise my clients. You can do that with an explicit agreement of your landlord, but I don't think in other situations necessarily, at least not around here.
Yeah, most people aren't going to fix it themselves. They're just going to withhold, and they want to do it indefinitely, and that's not going to work. Also, if they send a rent withhold letter and then they pay rent, the rent withhold is void, and they got to send another one. I've had that come up a couple of times, and there is actually case law on that. So if the client sends a rent withhold notice and then after they pay rent, it's void. You got to send another one. Why people do that? Usually because they're afraid they're going to get evicted. But just be aware of that. Payment after non-compliance works against landlords and against tenants if they send the rent withhold. So yes, Suzanne, were you saying something?
I was just going to say that if they pay rent after rent withholding, and a landlord, if they start to withhold rent, they can't claim offset for any months that they paid rent. So that's a waiver of that right as well.
Waiver works both ways. Christy's back.
Yes, that brings us to a quick poll. Does a tenant have to be current on rent before withholding rent?
Ooh, good question.
Super fast.
Good question.
All right, so we've got a majority saying yes, they have to be current on rent. Is that right?
Well, if you look in the statute, there is no explicit requirement to be current on your rent. So there is a case that I meant to have the citation for. I will put it into our shared drive. Certainly not in our area, but in South Florida, that says no, and the statute is not explicit. So I think the argument can certainly be made that you can send a rent withholding letter at any time. However, when we advise clients, we advise them that they should be current on their rent because it frankly invites an eviction for non-payment case that will be harder for them to defend, particularly if they're unrepresented. So if it's in that setting, it's a very difficult case to defend, but I think there is, good lawyering out there based on the statute and case law saying the answer is no.
Yeah, somehow that became a standard of practice throughout Florida. And I have to meet the person who started that. That you have to be current. I haven't been able to find it anywhere. I think it's accepted practice. So that's something you need to challenge. And I think the common challenge would be that the landlord is required to maintain the property.
Right. They're independent covenants, so.
Right. So that duty doesn't lapse just because rent has not been paid. So have fun with that as you wish, but
if you have a good judge and a court reporter, you may be able to make other cases to depend on. So other case law we can depend on. So.
What is the method of provided notice, Suzanne?
So there is one that was in these, that's in your PowerPoint here. And so you can follow that, but I would include in that also intent to terminate, but it's a written notice. I always advise my clients to hand deliver them if they can. And these days they can text and put one in the mail if they have a text relationship. The fastest way possible to get into the hands of one of the agents or landlord, but it's really set forth specifically in 8356. So you have to follow it closely or not at your peril.
And so you mentioned text. Can it be emailed?
I think so, yes. I think the fastest way it gets into somebody's hands, the better. And I always will have them send it by mail. I don't think it necessarily has to be by certified mail because certified, somebody can not pick it up. So it's something, any way you can evidence receipt. If you have to take a picture of your hand giving it to somebody, if you have to bring a friend with you, I tell my clients, you know, any way you can get evidence of receipt. An email is great, a text is great. So.
And you can do certified without return receipt. So that way they don't have to sign for it. You can just see that it got delivered. And first class letters, I believe you can also track delivery too. So there's lots of ways to track delivery. There's a question, what is considered casualty damage under 8363?
The only damages that I know people are entitled to in these cases is offset, some diminution of value off the rent. Other than that, you know, people can bring personal injury type claims if there's been a personal injury, but that's not something that we typically will get involved with. I'm not sure. Other than that, those are the damages I'm aware of.
8363 is if the premises are damaged or destroyed by wrongful or negligent acts other than by the tenant.
Mm-hmm.
And the tenant may terminate the rental agreement immediately or vacate the premises. If it's rendered, I think that is reflected in the statute, right? So if the premises is rendered unusable or a large part of it is, then you could terminate immediately. What comes to mind right away is a fire. If half the roof is gone for some reason because a tree fell into the building, those type of things. If it is anything you would think that you would normally call the insurance company for and they put you up in a hotel, I would say that's casualty damage. The stove not working? No. So I think we talked about this already.
Yeah. The only other thing is what I said before is you can request a reasonable accommodation at any time if there's a disability and it's being exacerbated
right.
somehow by what's going on, the conditions, and you can ask them to repair because their practice clearly is being bad landlords and not repairing. So you're asking them to modify that and repair. Alternatively, you can ask to be released from the lease if it's something material that a medical provider would say if the housing provider asks for proof is medically necessary, it's medically necessary for you to leave.
Mm-hmm. 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 And always give code enforcement a call. code enforcement, depending on where you live, is useful or not useful at all. So it really depends on where the client lives, unfortunately.
Very
So
true.
some code enforcement is very useless. And I found that to be true. All right, so what's the next one? Retaliation. So the landlord cannot retaliate for the tenant exercising their rights under local, state, or federal law, i.e. sending a 7-day notice for repair. So if the tenant properly withholds rent and the landlord files eviction, that is a complete defense to the eviction. Because that is in a legal eviction. If you call code enforcement, if you make a reasonable accommodation, you file a housing complaint. And federally, filing a housing complaint, after you file a housing complaint, and then there is an eviction filed, that's considered retaliation under the federal law also. So please be aware of that. Because I'm almost certain you will see a lot of this. You are going to see a lot of this because people haven't been paying rent for several months and they're going to want repairs. They're going to be calling code enforcement. They're going to want reasonable accommodations, and the landlord is going to go, enough, I want you out. So please, you are going to see a lot of this, a lot. Termination of tenancy. So how it's terminated depends on why it's being terminated, right? So if it's being terminated for non-payment of rent, that's what has to happen. 3-day notice. Certain public or subsidized housing, sometimes it's 7 or longer, 15, depending. So you got to know the type of housing. So the number of days really depends on the type of housing, right? So all of this is, in addition to all of this, subsidized housing provides extra protections, and that could be a whole presentation in and of itself.
And
So,
I believe it has been and will be in the future. I will put a link to a website where you can check the type of housing. Andrea is absolutely right. You got to know your type of housing to know what laws and regulations apply.
yeah, because subsidized housing, particular subsidized housing, has extra protections. So even against non-renewal of a lease sometimes. So you have to know the type of housing to know the extra protections. But this is just based on Chapter 83 alone, okay? The subsidized housing has extra protections based on the federal statutes. And you can include that in your eviction defense. So it's a very good idea to learn subsidized housing law protections and look into that green book, the green book, which is online now. So if you don't have access to that, you need to ask for it so you can check that, because that's very important. But right now we're just focusing on 83. So 3-day notice, it's a notice to pay or quit. It excludes, this is important now, Saturdays, Sundays, and court holidays. Know your court holidays. And the landlord may not refuse the full amount of rent, okay? And may not file the eviction before the 3-day notice deadline. Now, I've gotten quite a bunch of those in my time, where they give you a 3-day notice and then they file the eviction before the 3 days is over.
But in order to assert that defense, your client still has to deposit money into the registry. So
we're gonna have a
get there.
conversation about the registry, but yes. So I have a quick. I'm gonna call an audible. Does the 3 days include the day you were served in Florida? Does the 3 days include the day you were served? Ooh.
While we're waiting on people to respond, I just wanted to let everyone know that Zoom will send you this recording. So if you have to hop off since we're over our scheduled time, feel free to, and you should get the recording by tomorrow.
Yes, we're sorry. We had technical.
With us, no, everyone's had great questions and have been very interactive.
Yeah. And York, I see answers, and yes, nope, it does not include the day you were served. Excellent. You guys are on the ball. You don't really need us today. Have this. Then you have a 7-day notice for non-compliance. So the tenant will have 7 days to make the correction, and if the tenant still has not complied after 7 days, the landlord can begin eviction process based on non-compliance. If the issue is one in which the tenant should, this is with no opportunity to cure. If it's one where the tenant should be given the opportunity to cure, then the second notice for the same issue within 12 months is non-curable. And the rules may vary in public and subsidized housing. And like we said, you can, if it has to do with the person's disability, you could do a reasonable accommodation request. A lot of times you'll end up with this with HOAs and having to make repairs and things like that. And then there are notices based on the end of the lease. So if the lease doesn't automatically renew, the landlord can send a notice saying, okay, we're not going to renew your lease and we want you to leave. Or the lease may say if you don't renew, you're automatically month to month. And then you have those timeframes. Now that's the really tough part of month to month. It's notice based on how you pay your rent. And people think if it's month to month, you have to get 30 days notice. And that is untrue. That is not true at all. So if you are month to month because you want that flexibility, you can also be put out pretty quickly. Have to leave pretty quickly with proper notice. So clients need to be aware of that. And Christy's back with a poll.
I'm back. So this one is about mobile home park evictions. All mobile home park eviction notices must be 1, taped to the door, 2, mailed certified or registered mail, return receipt requested, 3, both, or none of the above. So I'm going to launch that real quick. Okay, we've got, most people say it has to be done both ways. We've got 60% say both.
Excellent. You guys are killing it. Oh, you guys are killing it. That's great. Like I said, you guys really don't need us today. Okay, I like that. I like that. All right, holdover tenants. So you're gonna be having this conversation a lot. I'm sorry, it's just, all of this is gonna be so much very quickly, right? So kind of, when I give landlord tenant advice, there's just a standard thing that I say all the time. So I hit all the same bases and then I'll specifically address the issue, but you always have to tell them about being holdover tenants because most people have no idea. And so if the tenant holds over and continues in possession of the dwelling unit or any part thereof after the expiration of the rental agreement without the provision of the landlord may recover possession of the dwelling unit in the manner provided in 8359. The landlord may also recover double the amount of rent on the dwelling unit or any part thereof for the period during which the tenant refuses to surrender possession. So, Suzanne, what do we think of this in light of COVID?
You know, um, this is again another issue where we're going to have to try and be creative, but I think the statute is pretty clear. So really what I tell people when I counsel them is people are not moving around at the moment. And so if you can negotiate a month-to-month agreement, if you had something written and you can negotiate an oral month-to-month agreement, do that, you know, anything, and then get evidence, memorialize it in writing, if get evidence of that, because you don't want to be a holdover tenant. You don't want to have to make creative arguments. You don't want to have to argue equity and COVID and pandemic. So that's typically what I tell people.
Yeah, COVID has created a brave new world, right? So there are no 100% answers to most of the things that are going to come up. You just need to use your advocate skills, pretend like you're in law school again, and throw everything you can at it and see what sticks. But do you think, Suzanne, that the moratorium says that, you know, you can't be evicted for non-payment, right?
Mm-hmm.
But it doesn't say anything about whether you can be a holdover tenant or not if you're supposed to leave and you don't because of COVID.
Right. I think it's pretty specific to non-payment evictions due to COVID. So I think it's going to be a hard argument, but it doesn't mean you shouldn't find a way to try and make it, for sure.
Yeah, I have no legal support for this. I'd argue impossibility. Where can I go? Where can the person go? Especially if it was during the lockdown, you know, when the whole state was locked down, where were you gonna go? Nowhere. You were not gonna go anywhere. So I would look at the months that they're claiming holdover tenant, right? So if some of those months were during the lockdown, the person couldn't leave if they wanted to. So at least during those months, they wouldn't be technically a holdover tenant. They'd have no choice. There was no option for them.
And you should talk to them about what they did, what their efforts were to try to leave too, because if they made significant efforts, that might be persuasive as well.
Yes, keep track. Just like if you were in a collection case and you were keeping track of the calls, keep a log of the places that they called to try and find an apartment and what were the results. Treat it like if they were on probation and looking for a job and they had to prove that they were looking for a job. Just like that. Just keep a log, a consistent log, you know, because a lot of times people think that because of the moratorium, they can't be evicted for anything and they can't be put out for anything. And that's not true. So you need to make sure they're clear on that. And you also need to, I would say in this situation, keep a log and at least make the arguments for the months on lockdown. Couldn't leave if they wanted to. After lockdown, where could they go? They made efforts and could not find a place to go. So a lot of this is going to be first impression. So you may really be making law. Isn't that exciting? I find it exciting. I find it exciting because there's no law really against you at this point. So how persuasive can you be?
Sure, there's a lot of opportunity for good advocacy out there.
Oh, yeah. Oh, I think so. I think so. This kind of stuff excites me because I love just trying to get the judge to go my way with absolutely no support whatsoever. But as long as there's nothing against you, then you're in the best position. You're in the best position. So the eviction process. You are served with notice. The landlord, well, this is how it's supposed to go, right? Doesn't always, but this is how it's supposed to go. The landlord files a complaint for eviction, you are served. The tenant is served and the tenant has 5 days to respond and deposit rent into the registry, except, and we'll get to that, in non-payment cases and some others. If the tenant doesn't do both, the landlord wins default judgment. So
the statute says in non-payment cases, the undisputed rent has to go in the registry. What we find on a regular basis amongst judges is that in all cases, they are requiring money deposited into the registry. So, and in some cases, if you can't deposit immediately after a status conference held, almost immediately after an answer is filed, default judgment, that's the registry. There's lots to be said about the registry, but it is a huge impediment to people being able to assert defenses if they don't have the money to put in, which now could be extraordinarily high, a lot of money because of the months that people have been otherwise given a respite during COVID.
yeah, and an undisputed portion of the rent is, in my experience, meaningless. If I, I dispute that I owe this amount, so I'll deposit this amount, judges are like, nope, because judges feel like they are supposed to make that determination. So,
and what the statute says is the judge is actually supposed to have a hearing before this goes to trial to determine the amount of rent that goes in the registry, and that never happens. So that's why you have to put in, your client has to put in the rent essentially into the registry.
Yeah, so I mean, unless you guys have experienced, you have a wonderful judge who does it any other way. I have never had undisputed portion of the rent deposit in the registry be effective. So just be aware of that. A lot of times it's the way it's supposed to go and the way it goes.
And I will say though, do file your motions to determine rent with the answer that you file. And if you attach evidence to it, at a minimum, you won't get to a default judgment if you put in less. You will likely not get to a default judgment if you put in less than what the landlord is claiming, because you have filed that motion and provided, if you have a judge who's going to look at it, and provided some evidence attached to it. So make sure you do your motions to determine rent if your client is disputing the rent, and have documentation. That's what the statute says, is that you're supposed to attach evidence.
Fingers crossed, you should not, right?
Right.
Sometimes you do anyway, but should be operative. But always do it, because if you don't do it, then you have zero chance. And we'll talk a little bit more about that in a few minutes. So defenses to eviction. So we have some affirmative defenses. If you are served with a 3-day notice and the landlord refused to accept it within the 3 days, that's a defense. The landlord accepts rental payment in full. The landlord failed to provide proper 3 or 7-day notice. The landlord failed to make repairs pursuant to a proper 7-day notice. The landlord requested wrong amount of rent. And of course, it says motion to determine rent, or landlord includes late fees that are not rent. So the lease has to say the late fees are considered rent for that to be proper. Retaliation, discrimination, including the failure to reasonably accommodate a disability, and COVID-related protections. So it just disappeared from my brain.
If you were going to be talking about the COVID-related protections, those are what we've been talking about. Those will extend into the period even after the CARES Act sunsets and the moratorium ends, particularly if the CARES Act will, if the amount that's being claimed is money that was not paid during the time of these protections. Those can be powerful affirmative defenses. I'm going to put my plug in for reasonable accommodation. At any time, you can ask for a reasonable accommodation, even in the midst of an eviction case. It's obviously not the best juncture to do it first, but it is certainly acceptable to do if it's something that you realize is necessary at that time. I'll also take a minute to plug our form builder that we've recently revised and added COVID-related defenses to at JALA. We've been working on that for the last couple months, and I'm going to put a link to that. It's designed for unrepresented tenants to be able to provide answers, but we also use it at the clinic that I coordinate, the eviction defense self-help clinic, helping people draft answers, asserting these affirmative defenses to eviction. So I will make sure to get a link to that form builder into the shared drive after this presentation. It's hot off the presses, just went live, I think, today. So,
and the form builder is excellent. So give it a look if you haven't already. And I remembered what I was gonna say. Senior moment, I'm back. So if the client is, if their rent is Section 8, another pop quiz, how much rent do they have to deposit into the registry? The full amount? Market rent? Or the amount of the rent that they are responsible for? And that would go to the landlord requesting the wrong amount of rent. What do you think? That's a pop quiz. For time's sake, I won't sit here and look at you till you answer me, but which I'm prone to do. But the answer to that is they are only required to put their amount of rent, not the entire amount of rent. So if the market rent is $900 and they pay $100, then they're only required to put $100 a month into the registry.
but do a motion to determine rent and attach something from your local housing authority saying what their rent should be, not not what the landlord is claiming.
Right, and the landlord never puts the subsidized amount of rent in the eviction action. At least here, they never say that. They just say this is the rental agreement and this is how much the rent is. And then by law, the client would have to deposit the rental amount, but you need to do a motion to determine rent saying that the rent is subsidized and they're only required to deposit this amount of rent into the registry. And I once had to tell a judge that. So there is case law to support you. Please make sure you have that at all times, especially if the judges rotate and it's a newer judge. You need to make sure you have that case law on you because that's important, because someone who's subsidized can't possibly pay full market rent. And you need to make sure that the court knows that. And then, like I said, there are other protections pursuant to that Section 8 tenancy that the client may have to eviction, including certain kind of notices and that type of thing. So make yourself aware. There are so many, I feel like there's less protections every day, but there's also a lot of other protections. So just keep that in mind when we're talking about the amount due. What is not a defense and very ironic due to the age of COVID is lost job, wages decreased. Another party to the lease didn't pay their share. The landlord failed to make repairs, but the tenant didn't send a 7-day notice in a medical emergency. So you'll get that a lot with the repairs. They don't say anything until they're getting evicted, and then they'll tell you all the things that are wrong with the apartment and that the landlord never fixed it. And then they want to argue that they shouldn't have to pay the full amount of rent into the registry or for the back rent, but they never did a withholding. You can still argue that and to the court and with documentation of what needs to be repaired. And I've done that, but it's no guarantee, right? So the only real protection to the eviction itself is a proper 7-day notice. What you argue then is how much should be in the registry based on the condition of the current condition of the apartment. And really, in the best circumstance, it's going to be going forward. You know what I mean? The amount of rent that should be deposited going forward is usually the best you can end up with. So do you think there's a way, Suzanne, we could use COVID to as a eviction defense other than an eviction that was filed contrary to the CARES Act and the moratorium?
Well, I think it does. Lost job wages decrease, which is never a defense. If the non-payment was during the COVID protected times, I think you have those defenses. The problem is that you have to, at the time that the case is filed, the tenant has to find all that money and put it into the registry to make those defenses. So I think it changes the dynamic a little if it happens during these times, but the reality is that could mean several $1,000s that a tenant needs to come up with that may not be able to come up with it because of the financial circumstances haven't changed.
Mm-hmm, mm-hmm. All right. Next one. Mobile home park evictions. They are 5-day notices. And what is also interesting about mobile home park evictions is that you can pay the amount you're behind even during an eviction, along with any other costs and attorney's fees, and get the case dismissed. So that's always something to look out for, as long as it hasn't occurred, twice before? Conviction of federal or state law ordinance. If there's an issue with public safety, they can give you 7-day notice without the right to cure. A violation of park rules. And then the second violation of the same promulgated rule within 12 months of the first violation, you get a 30-day notice to vacate, and curing is not a defense. So always read 723. I don't want to go into detail on that because we're running late, but read 723. There are differences, and it's important that you know it, especially if you do mobile home work.
And there's also requirements around the receipt of park rules for people, for tenants. So those often provide defenses. So read 723.
Now we said it twice.
Yes.
Okay, so we wanted to talk to you about going to court, right? So most of you have up to 2 years experience. So we're gonna kind of skip over this, but we wanted to talk a little bit about rent in the registry. What kind of arguments can you make in the age of COVID if an eviction is filed for non-payment of rent based on COVID? Are we seeing these kind of things? Because the statute itself says if you have to do a motion to determine rent, right? Unless you're arguing payment, right? So I'm gonna assume you're not gonna argue payment in the age of COVID. So if they file an eviction that is prohibited because it's for non-payment of rent, are you seeing the judges requiring rent being paid into the registry? And if the judge does require it, what can you do?
What I will say is we see a lot of orders. We're hearing of a lot of orders to pay into the registry. We haven't had a lot of a lot of cases filed in violation of the moratorium. But my personal belief is that everything should be on hold, including payment into the registry, based on the language of the governor's order. But not everybody agrees with me. And the good news is we don't have judges testing this because we haven't seen many evictions in our area.
Yeah, so I would say definitely motion to determine rent and use the CARES Act, the moratorium, to say that since the or a motion to dismiss the whole kit and caboodle because it's an illegal eviction, and say that there should be a motion to determine rent which says there is no rent that should be deposited into the registry because it's barred.
So these things can come up both as motion to dismiss because violating either the CARES Act or the governor's moratorium, or as an affirmative defense. And we've talked a lot about the CARES Act and mentioned the CARES Act, and all of you are, or most of you are probably aware, and that is in cases where there is either a federally backed mortgage or federal subsidies, and that's where those protections apply. So I thought I would just make sure, if we haven't said that, that we do.
Yes, that's important. One of the questions is, after a tenant receives a 3-day notice and the landlord then files an eviction, must the landlord accept the tenant's rent? If after the 3 days, no. There's the answer to your question. Okay, going. So if the landlord wins, I'm gonna try and go a little fast. Typically what happens is there's gonna be a writ of possession, and once it gets posted, within 24 hours, you gotta be out, right? That's on Chapter 83. In a mobile home, it's a little different because you have to get your mobile home out of there, right? And we joke about this. I have yet to see a mobile home that's movable, right? But some people do it, right? So you get a writ of possession 10 days after the judgment of possession, and that gives you in theory, I guess, time to get your mobile home out of there. And then once the writ is executed, they can move all your property and things out of the mobile home. They're not going to move the mobile home to the curb. They're just going to take over your mobile home and rent it to someone if you don't move it. So that's usually what happens with mobile homes. We talked about illegal self-help evictions, but these are examples of prohibited practices. And so we're skipping ahead for time's sake, right? And so changing the locks, turning off the water, all those things are self-help eviction. Security deposits, have a look at it. There are rules for when the security deposit should be returned, and notices for when they need to let you know if they're going to be, I think you have to hit forward again, if they're going to be keeping the rent, that type of thing. So have a look at that. Sometimes some of us do work in regards to security deposits, some of us don't, but just be aware so you can give the advice. But it's in here for you to read, so no worries. We're just trying to get you out of here at a reasonable time because we kept you over. So for those of you who are still here, the trends, I think sexual harassment will be a definite trend. Because you're going to have a lot of mothers and single mothers and men who can't pay their rent, just can't. And the landlord is going to make an indecent proposal, or the management, or whomever. Sex is a protected class. So keep your eye out and your ears. And when I say ears, a lot of times a person is not going to come right out and say they're being sexually harassed. They're not going to come right out and say they're exchanging sex for rent. So
any demands like this are fair housing violations. So
yep, all fair housing violations. They may say it nonchalantly, or they may not want to talk to, if it's a woman, she may not want to speak to a male attorney. So if the male attorney picks up on the fact that there has been some kind of exchange for rent, you may want to consider having the female attorney just address it with them to see if they're more comfortable doing that. Even with a translator, this is something that has come up recently. If you use an interpreter and the interpreter is male and the person you're talking to is female, she may not be comfortable speaking through that interpreter. So be aware of that and keep your eyes and your ears open on that. So that's a violation of the Fair Housing Act, and we should be seeing a lot of that. Like I said, prohibited practices, domestic violence, people don't have anywhere to go, they don't have any jobs. A lot of domestic violence. Consumer issues, bankruptcies. I am of the belief that bankruptcy is going to be booming as soon as this moratorium is listed. So if you don't know bankruptcy and you have some time, it's a good time now to learn it, because I think it's going to be a cash cow. And then probate, guardianship, wills. So you'll, unfortunately, and it's heartbreaking, people are dying from COVID. People have long-lasting effects due to COVID, so they may have medical issues that prevent them from caring for themselves. People in this time, and we've been seeing a lot of this here in our service area, people are looking for wills because they want to make sure their affairs are in order. Suzanne, anything you wanted to?
no, just it's important for advocates to share on listservs and things the trends that they're seeing, because things are going to be very different, and things are very different and very unexpected in these times. So make sure you get into a group, a list or something, so you can share and see what other people are doing.
Okay. Someone asked for a link to the Green Book online. I don't have it in front of me, but I will. I'll give it to Christy so she can add it to the materials later. Any final questions? I know we're running late, and for those of you who had to go, my apologies, but any final questions, anything you wanted to discuss? I think just kind of keep in mind, as Suzanne has said, always consider reasonable accommodation. If the person is disabled, always consider reasonable accommodation. I did a presentation previously with more fair housing information, and Christy has that if you want to look at it. So have a look at that also. But any final questions or thoughts, let us know. And I know we're late, but let us know.
Thanks for sticking with us, everyone. I posted the link to the Google Drive for the PowerPoint and any other materials the presenters would like to add. I also posted a link for the self-help, for the Pro Se Eviction Defense Builder that Jala developed that Suzanne mentioned. And you should get a recording of this webinar tomorrow.
And here's our contact information. Should you have any questions, do not hesitate to reach out.
Yeah.
And my contact information is on your registration confirmation. So if you would like the link to those videos that Andrea just referred to, it's a series of 2 webinars that are 3 hours each. So it goes way more in depth in fair housing. So just email me if you'd like those.
And if you enjoyed the presentation today and you got good information, please consider filling out the evaluation. Again, we apologize for the technical difficulty in the beginning, but
yes,
I think we finished strong. So I hope the information helpful.
Thank you, everyone.
Thank you. Thank you for being so engaged and asking great questions. I'll leave it up for a couple seconds. That way everyone can get the links. And I'll also include those in the follow-up email that you'll get with the recording. All right. Thank you, everybody. Have a good afternoon.
Thank you.
Bye.